Like many remedies questions, the one that was administered on the California bar exam back in February of 1998 had a fair amount of intimidation value. But this problem, like most other remedies questions, can be divided and conquered efficiently. Let's have a look together. Here the call of the question doesn't give us a lot of help. What evidence must NASS produce to make a prima facie showing on each of its claims? What defenses might halfway reasonably assert, and how should this court rule on each of NASS's claims? Discuss. Well, we know that NASS is going to have one or more theories of liability, probably more than one, and one or more prayers for relief. And we will split it up into elements, and we'll talk about the pieces. Go to the top of the question, and as we get into it, we will see that what makes this fact pattern difficult is the plaintiffs are going to have a great deal of trouble establishing their theories of liability. It is factually complicated, but legally simple. In paragraph 1, we meet Halfway, Inc., a nonprofit organization, state licensed, to assist in the rehabilitation of former convicts. It has a 5-bedroom house in a residential neighborhood of well-maintained single-family homes. The house, purchased by Halfway, is on a parcel zoned for multiple family use, as is a small apartment building across the street. The remaining parcels are zoned for single-family use only. But if you read this without reading the call of the question first, it might look like a real property problem. In fact, it's a remedies question. Now look at the second paragraph. For the last 3 months, Halfway has been using the building as a halfway house for parolees from state prison. And this paragraph contains lots of details about their operations. 6 or 8 parolees are there at a time. Mostly they are former sex and drug offenders with high recidivism rates. There is strict supervision by at least one resident director on the premises at all times. Then we're told that Halfway has a good history. They have successfully operated halfway houses in 3 other residential neighborhoods, and they are successful because the behavioral influences inherent in established residential environments helps. So at this point, we're about a third of our way through the fact pattern, and it doesn't look as if there are any real issues so far. The halfway house hasn't done anything wrong. They are operating within zoning, and they appear to be successful. So in paragraph 3, we meet our plaintiff, NASS, a neighborhood association that wants to stop this halfway house from operating. They are concerned about their safety, the safety of their kids, and their property values. The only problem is none of these concerns so far are backed up by any facts. They are mere worries. Next we read about that while the halfway house was being renovated in preparation for the parolee program, one of Halfway's employees, not a parolee, assaulted a woman who lives in the neighborhood and is a member of NASS. Okay, stop right there. This assault doesn't have anything to do with the operation of the facilities. And thus, if the plaintiff is going to try to stop this halfway house from operating, they're going to need to show something a lot more than this incident that occurred during the renovation. Next, in the following paragraph, NASS discovers that 20 years ago, an injunction had issued and had been recorded in the chain of title of the parcel Halfway is using that prohibits the use of the property as a residence by unmarried persons living together. The injunction had issued because a group of college students, while living in the house, caused disturbances with late-night parties and loud rock music. Well, rather than comment on our misspent youth, we proceed. In the next paragraph, we finally get to the meat of the complaint from NASS. They have sued Halfway. In its complaint, NASS asked for an injunction against operation of this halfway house on the parcel because of public and private nuisance. Great. They give us 2 different theories of liability. We will carefully examine each one of them in our answer to the first call of the question. Next, NASS seeks a declaratory judgment that the 20-year-old injunction is an in rem injunction that prevents Halfway from operating a halfway house. Well, that's a much closer call. And it's also an interesting question. It also poses a crossover from civil procedure. Remember, all of these subjects really are just one big subject, practicing law. The bar exam likes to combine issues in subtle ways like this one. Well, my first reaction is that this plaintiff is likely to have more luck with its in rem theory than with its nuisance theory. Once again, we reach the call of the question, and it's time for us to come up with a literate, sensible answer. So again, what makes this problem difficult is not that it is legally difficult, but that it is factually complicated. And in fact, we don't even really need to dream up the theories of liability. They spoon-feed them to us in the fact pattern. So now please turn the page. Let's have a look at my outline of issues and see how one readily could organize a winning answer to this tricky problem. First, I consider the lawsuit between Nass and Halfway. And notice, I find a home for another civil procedure issue, association standing. And here, although I don't think it is anywhere close to the core of the question, I do think it's worth talking about. And thus, we have a little section on association standing up front. Then we go on to consider public and private nuisance. To establish a public nuisance, a special injury has to be established, and then we focus on the public safety, health, and property. Then we go on to consider private nuisance. Here there's got to be an intentional interference with the use and enjoyment of property. We engage in a balancing test to establish private nuisance and reach a conclusion with regard to whether or not the plaintiffs have even stated a claim for private nuisance. Then we consider the defenses of the halfway house, and even though, as you could well intuit, my sympathies are very much with the defense in this case, we go on to consider the prayer for relief that we've been instructed to consider. You'll see that I break it down into elements. In the end, I conclude that no injunction is going to issue for this plaintiff. Next, we consider the declaratory judgment, and here there's plenty of room for reasonable people to differ. I talk about the theory, the defense, I reach a conclusion. So organizing the second call of the question is not very difficult. It's the first call of the question that is demanding. And without a rigorous approach, both to organizing and to finding a home for the facts, it's likely that an otherwise literate answer to the first call of the question would suffer from being incomplete. And the most common reason, in my judgment, that people failed this fact pattern was they did not come up with a complete set of issues before they started writing or typing. That was the fatal mistake. So let's now take a careful but a fairly brief look at my model answer. First, under Nass versus Halfway, I have a section on association standing. It only takes a couple of fairly brief paragraphs, but you'll see that I find a home for the basic details of association standing, and I think that these plaintiffs have done enough to show that NASS ought to be able to pursue these claims. I think the problem with the plaintiff's case isn't association standing, but their problems in establishing the theories of liability. First, I turn to private nuisance. Notice up front the difference between public and private nuisance. The problem is that there's a special injury required. Here, the only thing they can show is the assault that happened during the renovation of the halfway house, before it even opened. Even if we consider that the victim would have standing, probably NASS would lack standing to pursue this claim. Next, we turn to the public safety, health, or property, and here the problem is, again, the plaintiffs can't show an injury. They have concerns, and honestly, I think these are legitimate concerns, but the problem is the plaintiffs haven't shown any harm, and as a result of that, it looks as if their claims really are speculative. We move on to consider private nuisance, and here we would go through a balancing test, which, again, I think favors the defense. Halfway has a proven track record of success. There have been no incidents here since the halfway house opened. And so, ultimately, I conclude that NASS has failed to show any injury. So we move on to consider equitable remedies, even though we have already expressed our hostility to this claim. Here I'm not doing anything very scholarly. I'm just breaking down our analysis of injunctive relief into the elements that all of us have been studying since the first year of law school. And you'll see I don't waste a lot of time on them. But notice, we engage in a balancing test again, a second time, when we do our equitable remedies analysis. And that's something that can be very useful. If you are facing a nuisance problem on an essay, there's a balancing test involved in establishing a private nuisance. And so a plaintiff has to face two balancing tests. One to establish the theory of liability, and the second one to justify the prayer for relief. And it seems to me that NASS is not going to be able to establish either of its nuisance theories, and even if they could, I would deny their prayer for equitable relief. Next, we focus on the declaratory judgment. See here how I lead with the facts, and I think it's an interesting theory. And if correct, it would be an independent justification that could cause the halfway house to be closed without any finding of nuisance. Now, I focus on the defenses because here the analysis is a little bit more complicated. It looks as if this injunction was directed at a very different type of defendant. Plus, this neighborhood is not too concerned about unmarried people living in the same building because of the fact of the apartment building across the street. So, I conclude that the old injunction is not in rem, and so halfway wins here also. But let me just pause for a moment and offer a very strong caveat. I don't think that this is the, quote, correct answer to this part of the question. It is the answer that I choose, and the one that, personally, I find to be more persuasive. But I can tell you for sure there were many passing applicants who got passing scores on this essay and on the bar exam who reached the opposite conclusion. Here, with regard to the in rem theory, the fact that this was recorded in the chain of title struck many as persuasive, and I don't think they were unreasonable in being so persuaded. So, with regard to the first half of the answer, I think the mainstream answer was for the defense. I just don't think the plaintiffs really have shown either a public or a private nuisance in Halfway's operations. But the in rem theory, with regard to that earlier injunction, is a much more subtle and potentially a much stronger approach for the plaintiff. It just happens to be one that I, and probably a majority of successful applicants, chose not to side with.